down to one prior felony. And then the third file, 20-23583FH. Again, breaking and entering a building with intent to commit larceny. We would expect the guilty plea to that, and we will reduce the supplement down to one prior or second sub. The remaining 4 files would be dismissed with the understanding that restitution is going to be requested on all of the files. And if after review of the receipts, Ms. Hines has an issue, we certainly will entertain that and be entitled to a restitution hearing if they request it.
That is correct. That's my understanding of the offer.
Okay.
I neglected that I will be asking that the sentences on these 3 files run concurrent, not consecutive. But court, I'm sure, is aware or should be aware that Mr. Curtis is on parole. So there is that issue as far as.
Yes, okay.
PRD.
All right, so Mr. Curtis, the offer is that you would plead to a charge of, in file 2023564 of squatting. That is a misdemeanor punishable by up to 180 days and or a fine of up to $5,000. They would dismiss the felony charge and the habitual related to that. In 2023580, the offer is that you plead to a charge of breaking and entering a building with the intent to commit larceny as a habitual second offense, which would make it punishable by up to 15 years in the Department of Corrections. And file 2023583, which is also a charge of breaking and entering with the intent to commit larceny as a habitual second, it would be punishable by up to 15 years. And the agreement is that they would dismiss the habitual fourth for a plea to a habitual second in those cases. They would also dismiss files 2023578, 2023579, 2023581, and 2023582. But you agree to pay restitution for those cases even though they're being dismissed. Prosecutor would recommend that all cases run concurrent with each other but consecutive to your parole. Is that your understanding?
Yes, Your Honor.
Okay. So let's do the first case, the misdemeanor case, and we can resolve that one right now. Okay, so what's that, Mr. Curtis?
Before I plead, can I read something? Can I say something?
Well, go ahead.
I'm always accountable for and responsible for my own actions. I know right from wrong. These current charges I am guilty for, and I owned up to them with Sturgis PD detectives. Told my cooperation would be taken into consideration. My attorney, Ms. Hines, informed me that this is the only plea I will receive from Mr. Gregory. After my release and reparole from LaGrange, Indiana jail back on October 5th, I was released to nothing and made the only choice I assumed that was available to me while I was under duress and in distress to my own situation at that given time. When released to no assistance or support from anyone, having all my property taken from me. Others see this as an excuse for me making all the wrong choices throughout my life within the legal system. Not someone institutionalized since the age of 10 with mental health disorders, but always a survival and financial issue upon my release from jail or prison sentence for me. I did break into said 5 buildings and was squatting in an abandoned house in Sturgis. I did remove food, cash, clothing, and personal property from 4 buildings. On October 19, 2 individuals, William Days Jr. and Eugene Madison, came to said residence. I had been squatting for shelter. Someone removed stolen items and personal property. Then contacted Sturgis Police to what they found. Sturgis PD detectives removed items on the 19th of October, but left others. They failed to properly secure sent evidence on the 19th and the 28th of October when I was caught in said house. Items not recovered or just not returned by detectives has resulted in higher restitution amounts. I requested all photos from crime scenes and house for items and damages reported, but not received. Made a list of all items stolen and my personal property left in house with property manager Timothy deeming had access to. I even sent that to the Sturgis chief of police because I feel the evidence was not collected on both dates and items have not been returned to the property owner. So all items other than food that were in that house at the time. So I don't know what, it's all been alleged for restitution. I've already wrote apology letters and I asked them to send invoices to me and my attorney. I've never received anything from any of the building owners. I did not contact the property manager because when I was arrested on the 28th, everything was left in the house. My attorney already seen that too. But I am accountable for my actions. Always have been.
Good. All right, and as they said, those restitution figures will have to be based on evidence, and whatever you don't agree to, we can have a hearing on. So that's completely.
I'm guilty of the deductible. I'm guilty of the deductible, so it's okay.
We'll have a hearing on that then to determine what the exact figure should be. Okay, so. Okay, good. All right, so let's go back to 2023564. In this case, you are charged with squatting. As I said, that's a misdemeanor punishable by up to 180 days and or a fine of up to $5,000. They would dismiss the home invasion and the habitual fourth offense. How do you plead to the charge of squatting?
Guilty.
Has anyone promised you anything other than what we've talked about in court today?
No.
Has anyone threatened you?
I'm told this is the only plea I'm gonna get, but no.
Well, that's a statement of fact. That's not a threat. That if you don't do something,
okay.
That's just the way it is. So, yeah, that's not
I'm
a threat.
guilty.
That's a reality. And then, has anyone, are you doing this of your own free will?
Yes, Your Honor.
All right. And now for all these cases, I don't want to have to repeat everything over and over again. I just want to make sure you understand. You understand that if I accept your plea, you're giving up your right to a jury trial and a trial of any kind.
Yes.
So you're giving up
Yes,
the
Your
right
Honor.
to be tried by a jury, to be presumed innocent, to have the prosecutor prove beyond a reasonable doubt that you were guilty, to have the prosecutor present witnesses that are going to testify against you in court, to cross-examine those witnesses, to have the court ordering witnesses you want to appear for your defense to appear in court. You'd have the right to remain silent and not have that silence used against you, or the right to testify if you wish to testify. You understand those are all your trial rights, and you're giving those all up for all these cases.
Yes, Your Honor.
You also understand that if your plea is accepted, you may be giving up the right to appeal certain issues that would otherwise be appealable, and your conviction and sentence pursuant to the plea would be by leave and not by right.
I don't understand it, but yes, Your Honor.
Well, then don't say yes, Your Honor. So if you don't understand it, what does it mean? Well, what does it mean? It means that, you know, when you go to jury trial, you have an automatic right to appeal. So the Court of Appeals has to look at the case. When you plead guilty, they don't have to look at it. They'll look at it, but they don't have to review it if they decide that there's nothing there to look at. So that's the difference between the two. And then the first one is also, when you plead guilty, you're giving up any possible defenses you may have by pleading guilty. So, you know, you can't come in and say, the classic example that I use is for an assault and battery, you know, and then the person wants to come back and say, but it was self-defense. Well, you give up that defense by pleading guilty to the assault and battery. If you want to assert the defense, you need to go to trial. So I don't know if there's any defenses here, but this is a blanket instruction I give to everyone. You understand that?
Yes, Your Honor.
Okay, so you understand you're giving those up by pleading guilty rather than going to trial and then preserving those issues. All right.
Yes, Your Honor.
All right, so it says that on October 28th, 2020, you were squatting. You occupied a building that was a single-family dwelling in the city of Sturgis, county of St. Joseph, without the owner's consent for an agreed-upon consideration. Is that true? I think you already said this earlier,
Yes,
but I
Your
want to make sure we got it under oath. So you went into that home and you were staying there because you were homeless. You didn't have a rental agreement or anything with the property owner.
No, Your Honor, I was there from October 5th to the 28th, and I was squatting. There was an abandoned house on it. There's a sign, it's an abandoned house. It was open.
Okay.
No power,
All right,
no water.
Okay. Are council satisfied there's a factual basis to that count?
Yes, Your Honor.
Yes, Your Honor.
Are council aware of any of the promises, threats, or inducements?
No, Your Honor.
No, Your Honor.
Has the court complied with the court rule?
Yes, sir.
The court has.
I find the plea made is accurate, understanding, voluntary. There's a factual basis. Therefore, I accept the plea. Mr. Curtis has spent 189 days in jail. Misdemeanors are not mandatorily consecutive to the parole cases. So I would sentence 180 days, credit 180 days, $75 crime victims' rights fee, or I'm sorry, $75 court cost, 100, what is it? 68?
75 crime victims state cost.
Oh yeah, it's a misdemeanor. I get them confused because I'm used to felonies. $50 state cost, $75 crime victims' rights fee. Is that agreeable, Mr. Gabriel?
Yes, Your Honor.
Ms. Hines?
Yes, Your Honor.
There's nothing else we can do. Mr. Curtis, you've already given a little summation on that. So that case is now resolved. Is there anything you wanted to say on that one in addition to what you already said?
I'm just indigent and homeless still, Your Honor, so I'm not unable to pay at this time, so.
Okay, well those are the mandatory state costs. I didn't order anything other than what the state requires me to order. And we will set up a payment plan with you if you need, or we'll take that into account, okay? Okay, now let's go to the two felonies that we'll need pre-sentence reports on. In file 2023580, here there's a charge of breaking and entering a building with the intent to commit larceny, a felony punishable by up to 10 years normally, but you're going to plead as a habitual second. They're going to drop the larceny in the building, and they're going to also drop the remainder of the habitual offender notice. And again, they're recommending that all these cases run concurrent with each other but consecutive to parole. How do you plead to the charge of breaking and entering a building with the intent to commit larceny as a habitual second offense?
Guilty, Your Honor.
And you, again, all the trial rights that I read earlier, you understand that you're giving all those up.
Yes, Your Honor.
And no one has threatened you or is making you do this. You're doing this of your own free will. Is that correct?
No, Your Honor.
No?
I mean, yes. Sorry. Yes, Your Honor. Sorry. My bad.
Yeah, I try and switch them up so that they're not all the same. But yeah, no, yeah. So
Yes.
let me break it down then. Has anyone promised anything other than what we talked about in court today?
Yes, Your Honor.
Okay, listen to the question, Mike. You're getting ahead of yourself. Has anyone promised you anything more than what we talked about
No,
in
Your
court
Honor.
today? Has anyone
Your Honor.
threatened you? Now,
No, Your Honor.
here's the tricky one. Are you doing this of your own free will?
Yes, Your Honor.
Okay, see, 2 no's and a yes. That's why I do it that way. All right, Mr. Curtis, it's alleged here that on October 15th, 2020, you did break and enter an office located at 202 East West Street in the city of Sturgis. Did you break into that building?
What, is that the Farm Bureau?
Yeah,
Yes,
Farm
yes, I
Bureau.
did.
All right,
Yes,
and
I
did you
did.
do so with the intent to steal something?
Yes, Your Honor.
All right, and all right, so we're counsel satisfied? Oh, and you admit you have at least one previous felony conviction?
Yes, Your Honor.
All right, counsel satisfied there's a factual basis?
Yes, Your Honor.
Yes, Your Honor.
All right. And in file 2023583, this is a charge of breaking and entering a building with the intent to commit larceny as a habitual second, punishable by up to 15 years. How do you plead to that charge?
Guilty.
Now, again, has anyone promised you anything else to get you to plead?
No.
Has anyone threatened you?
No.
Are you doing this of your own free will?
Yes.
And you understand you're giving up all your trial rights?
Yes.
All right, here it describes an incident on October 13th, 2020. in the city of Sturgis, County of St. Joseph, where it alleges you did break and enter a church located at 410 South Clay Street with the intent to commit the crime of larceny, and this would be the Four Square Church. Did you break into that building?
Not on that date, Your Honor.
Okay, what date was it?
October 5th, when I got released from the LaGrange jail, when I walked to Sturgis.
Okay, so October 5th, you
October
broke
5th.
into that building.
Yeah.
All right, and what,
Yes,
did
sir.
you do so with the intent to steal something?
Food, clothing, and water, yes, Your Honor.
All right, are counsel satisfied there's a factual basis in that case?
Yes, Your Honor, and we'd ask the court to accept the amendment to the information reflecting the defendant's statement.
All right, thank you. So we'll go with the October 5th date. All right, Ms. Hines,
Yes,
you
Your
agree?
Honor.
All right.
Yes, I
And
agree.
are either one of you aware of any other promises, threats, or inducements for any of these cases?
No, Your Honor.
No, Your Honor.
Does the court comply with the court rule for all these cases?
The court has.
The court has, Your Honor.
All right, I find the pleas made are accurate, understanding, voluntary. There's a factual basis. Therefore, I accept the pleas, and we will set these for sentencing on June 18th. Mr. Curtis, fill out that packet so they can update your pre-sentence report. And what I want to have happen is, please get that material as related to the restitution for each victim in the other files and these, so that Mrs. Hines and Mr. Curtis can look at that. And if there's going to be the need for an evidentiary hearing, let me know as soon as possible so that we can then set it for a different date other than on a busy sentencing day. Okay?
Your Honor, I did, Ms. Countryman sent those to me just as we were taking the pleas. So I will print them out and then I will get them to hand deliver them to Michael at the jail.
Okay, good, good. And then you can go through those, and those things that are not contested, indicate to Mr. Gabriel those things that are, and then he can contact the victims and see just where they want to go. Okay? What were you going to say, Mr. Curtis?
Can I get the list of items they removed from the house on the 19th and the 28th from Sturgis PD? What they took, or pictures or whatever?
Okay,
I've been asking that.
Clearly, Mrs. Hines will be addressing that issue with Mr. Gabriel. So yeah, I mean, we'll have that. We'll find out what's going on there, and that may be the need for an evidentiary hearing too. Okay, that concludes our hearing for the day. Then, thank you, Mr. Curtis. That resolves a lot of cases, and